So, distinguished guests, ladies and gentlemen, welcome to our first sessions of the World Judicial Integrity Forums of 2026. My name is Nhonlaphat Pitpiboonpreeya, Director of the Bachelor's of Laws program from Faculty of Law, Rangsit University, and I will be your moderator for today's sessions. So, ladies and gentlemen, in our first sessions, we are going to start with the judicial independence, accountability, and public confidence across Asia. And we are honored to have the experts from both Malaysia and Thailand to be our panelists today. So without further ado, ladies and gentlemen, please welcome our first panelist, Mr. Mohamad Izahar bin Mohamad Izham from Malaysia. He is partner and head of the government advisory practice of Zaid, Ibrahim and Company. Our next panelist, ladies and gentlemen, is Professor Prasit Eakabut from Thailand. He is the expert in the international law and currently a senior professor of Doctors of Law programs. Next panelist is Dr. Pratamaporn Iamumpha from Thailand. She is a lecturer of law and also the independent legal practitioners as well. And our last panelist is Police Colonel Dr. Siriphon Kusonsinwut. He is the Director of the Legal Affairs and Deputy of Secretary General of the Office of the Personal Data Protection Committee of Thailand. So, ladies and gentlemen, as Asian societies evolve, judicial system has been scrutinized about judicial conduct, decision-making process, ethical standards, backlogs, and delays. Therefore, in these sessions, we are going to tackle the practical approach of how we can enhance the accountability and transparency while still maintaining the judicial independence and autonomy to gain public confidence across Asian jurisdiction. And we shall discuss this topic in a comparative manner as we have the experts from both Malaysia and Thailand who have expertise at international levels. So, ladies and gentlemen, without further ado, I would like to invite Mr. Mohamad Izahar bin Mohamad Izham to commence his opening remarks.
All right, thank you, Madam Moderator. Good morning, everyone. My name is Izahar. As introduced earlier, I'm a partner from Zaid, Ibrahim and Co. Malaysia. It's actually an honor and a pleasure for me to be here today on this esteemed panel. Thank you, organizers, for inviting me to this event to share my kind of insights and thoughts in this area. I'm not actually an expert on the judiciary. I just want to qualify that. My area of practice is quite unique. I'm a lawyer, but I'm not your traditional lawyer, so I don't go to court, I don't draft documents. But what I do is I draft policy. And I think kind of resonating with what Dr. Artit said in his opening remarks, I do law reform. So usually the work that I do comes in before it goes to the courts or after it's interpreted by the courts. So it's quite interesting because I found my passion in kind of shaping law and policy, but not through the judicial means, so it's non-traditional. I would say it's not legal per se, not to say that it's illegal, the type of work that I do, but it's quasi-legal. It borders along legal and consultancy. I advise governments on basically drafting laws, drafting policy, and also implementing those policies. I've done work in Malaysia a lot for many federal bodies, federal government bodies and agencies, and also in the region. Actually, most recently, I'm doing a lot of trade policy related work. So that's just a bit of my background for you to understand how I come into this topic. Maybe I'll just go through the slides to give you a bit of insights in terms of what I want to talk about today. So from a law reform or public policy perspective, I think it's good to set the stage on the judiciary. So I think everyone on this panel knows, it was mentioned during the opening remarks, the role of the judiciary is to interpret decisions, right? And also to make sure that those decisions are right. I think if you look at my slide, and of course I have judges from Malaysia here, so I can't go into the specific cases, but you know, in terms of the themes or topics that affecting the judiciary in Malaysia, I think it's common in most countries, right? In Thailand as well, in any ASEAN jurisdiction and across the world. The first one that I was highlighting in the slide here, if you see it, is on the interference. I know I said executive interference, but it actually could be from any branch or anybody outside the judiciary itself. So interference is a key issue, and I think that is quite consistent across the various jurisdictions. The second one, of course, if you look into, is the public interest or public scrutiny. So when we talk about, you know, for example, high-profile cases, of course, everyone becomes a lawyer then. Things are known publicly, and everyone gets a lot of data information. I think this also fits nicely to the third point that I'm trying to make, which is the evolving legal landscape, because I think one of the panels today is also on technology and on AI. So with AI, we don't really know what's true. There's a lot of false information being spread. So when cases are being tried and you know this information is circulated through social media, through WhatsApp, we don't know whether we're getting is true or not. And to make matters worse, everyone becomes a lawyer because they get this information, they put it through AI, and then they think they know what's best, and they try to give their own opinion. Now, having that as a backdrop in terms of the issues, which I think is common across, you know, all jurisdictions, I think the next point that I want to make, sorry, the slides are not changing, but okay, let me point at the, okay, there is it. No? Ah, there, thank you. So the next point I'm trying to make is that we can't look at the judiciary issue in silo, right? We know the three arms of government. We have judiciary, legislative, and executive. I think it's important to identify that this is not a judiciary issue in isolation. If you look at the chart that I put on the right, I just call it a very simple prosecutorial chart. We have the flow from the legislative actually developing the laws, which is, you know, your parliament. Then you have your executive implementing the laws, and then finally it goes to the courts to interpret. Now, if we only look at the issue from a judicial perspective, you're only rectifying or addressing one part of the problem, but you're not actually looking at the whole ecosystem. So for example, if Parliament drafts a very bad law or poor law, I think Dr. Artit in his opening remarks said that the laws are old, the laws are archaic. Therefore, when it comes to implementation and interpretation, people of today will have difficulty in trying to understand and implement that, because we don't know, you know, what the intent was at that point in time. The law may be 50, maybe more than 60, could even be 100 years old. We don't have 100 years old law in Malaysia. I'm not sure about in Thailand, but we do have some before independence, which dates back more than 60 years. Again, on the implementation side, if the laws are not implemented well, they are challenged again, and this also puts pressure on the judiciary at the end, not on the executive side, the ones who are actually implementing, but the problem comes to the end, which is at the judiciary. So these are some things that actually I think supports the contention or idea that it is not just an isolated problem, but you have to look at the whole ecosystem if you want to improve the process. Now I move on to some of the reforms. I'm not going to go into so many right now. I know I have 5 minutes. So I think the key one for Malaysia is that we have a Judicial Appointment Commission Act. I'm not going to talk about in detail because I think you have some of the questions there. But we've actually codified that process and have established a commission to allow for judicial appointments. I'll move on to the next slide, and this is more about executive reforms. I think the two key ones actually happening now this year in Malaysia is, number one, we're trying to separate the Attorney General's role and the public prosecutor, and number two is we're trying to limit the term of the Prime Minister to 10 years. That's the most latest. I think you can read, I think in terms of the slides, you know, all the developments. And then the last one is from the legislative perspective. So I think three key points, and I think this is also common in most countries. Some of the reforms, of course, ties back to good regulatory practice principles. I believe in Thailand you also have the same concept. You need to review laws every few years. In Malaysia, that's 5 years, number one. Number two, I think the key concept is we have a government Public Service Efficiency Act, which will actually require ministries and agencies to cut red tape by 25%. But more importantly, before you introduce a new law or regulation, I think most of you would know this, there's a one in and one out principle. So you have to remove one law before you can introduce another one. And the last one is to actually establish or incorporate and embed this good regulatory practice tools. So using tools such as sandbox, using tools such as agile regulation in your regulatory delivery, your regulatory design, making sure that when you design these laws, they are fit for purpose and not too prescriptive, which also, you know, in most cases creates that burden and backlog with the judiciary. So I've touched on these three concepts, and I think I will just leave it here for now for my presentation. But I think the conclusion that I'm trying to make or trying to drive, number one, it cannot just be a micro solution at the judiciary. There are solutions, there are interventions to improve judicial integrity, independence, and also instill public confidence in the judiciary. But the second one, in order to address that, it has to be that whole of government or whole of ecosystem approach in order to better the judiciary. Thank you.
Thank you very much, Mr. Mohamad Izahar. So it is essential, as he mentioned, that we need to cooperate not only in judicial in isolation, but also legislative part in terms of design the proper law, and also the executive interference and management. So it's valuable insight. So now I would like to invite Professor Dr. Prasit Eakabut to deliver your remarks.
Yeah.
Not belong to me. Not this one. Yes, this one. Okay, thank you. Thank you so much. First of all, I would like to introduce you. My topic today is judicial independence and judicial reform. Why we need to have judicial reform? The problem is our nations around the world, in all nations around the world, the most difficulty in terms of judiciary system are based on the independence of justice. Most of government, most of dictator, most of ruler, they always ignore the reality of the justice. They try to intervene so many frequency, every day, every time, by telephone justice, call some judge, don't make that decision. You must make that decision in favor of my political status. This is a big problem, that how the judges will not be a slave of the dictators. In democratic country, judicial independence is quite necessary, and it is a must for the democracy regime. So it's pity that many developing countries or least developed countries encounter the big problem of interference by executive power and by other persons, sometimes by mafia or by gangster or by prisoner in the jail, can telephone to the chief judge and make a lot of unbelievable decisions from the court. That's why it's quite so sad story. If judge is under the pressure of someone else. So I would like to show you what does it mean, judicial independence. According to the definition broadly that I try to summarize here, judicial independence is the principle that courts and judges must perform their duty free from improper influence, coercions, or controlled by other person. That person may be politicians, that person may be the head of state, that person may be the head of government, that person may be the owner of some political party, that person may be the media, or that can make a lot of influence in terms of social trend, in terms of public opinion change according to their political will. That is quite difficult if the judges have no freedom to make its own decision based on the rule of law. So next, I would like to show you about the key component of judicial independence. First of all, independence of the judge need a lot of freedom. So court and judges must be free from any kind of judicial interference, namely political interference in the judiciary, executive interference, or improper influence, or undue influence. Not only independent of the judge need to be impartial judge. Impartiality is the basic principle of the judge to perform their duty. Judge must act without fear, without favor, or without bias. And judge must have a good salary too. In some countries, judges are poor, so they can make a lot of corruption. Under table, dirty money go to the hand of the judge by big bag or by the big James Bond bag. That's why a lot of million dollar can pay back to the judge. And some judges, unfortunately, some judges make corruption. And how can we get rid of the judge like this, the bad judge like this? It depends on judicial reform, right? If we have a good accountability of the judge, code of conduct of the judge, and we have a severe sanction based on criminal law, severe sanction against the dirty judge like that, I do believe that justice can be prevail over the politics, over the politicians for sure. Another component is the financial security. So judges' salary cannot typically be reduced during their term and must be protected from the financial pressure. And final, the guardian judge must play the role as a guardian of justice as well. Judge must protect the rule of law. Judge must protect justice. And judge must protect human rights. Why I emphasize on human rights? Because in many countries, just think that just think that they have their own discretion to make judgment, to make decision, without thinking the freedom of people, without thinking the minimum protection standard under international law about the human right of people. So sometimes some judges didn't think about the provisional release in criminal case, for example. They think that in order to make sure that the accused person will never leave the country or leave out from their jurisdiction. So just did not provide easily provisional release or provisional bail. that is not correct. That's why I would like to think about the reform. We go to the next slide.
We have a very brief
Yeah,
time.
maybe later
Wrap
on,
up.
judicial
Yeah, yeah.
reform, I think.
Yeah, maybe
Thank
we
you.
later on, or we can cooperate in the Q&A sessions about
Okay,
this.
thank
Okay,
you.
thank you very much, Professor Prasit Eakabut, for your valuable insight. And now I would like to invite Ms. Pratamaporn Iamumpha to give her opening remarks.
Okay, first of all, thank you for inviting me today. And for briefing my opinion with this topic, it's just only 3 essential topics for for the first issue. I think I'm focusing on the balancing between the judicial independence and public accountability. The judicial independence is essential, but we have to balancing that the modern society increasingly demand accountability from all public institutions, including the judiciary. Court must therefore maintain high standard of ethics, professionalism, transparency, and institutional integrity. This create a difficult but necessary balance. And if courts become too vulnerable to public or political pressure, judicial independence may suffer. But if courts appear too distant or inaccessible, public trust may also decline. And the second challenge is what we may call trial by public opinion. Today, social media can shape public perception before courts have fully examined evidence or legal arguments. A short clip or incomplete information can spread rapidly and create emotional reaction within hours. So this means that courts today are not operating only inside courtroom. They are also operating in a digital environment where information moves faster than legal proceedings. And the third challenge is the access to justice and delay in proceeding. Many people still view the justice system as a complex, expensive, and time-consuming. Even a legal correct judgment may lose legitimacy in the eye of public if justice arrives too slowly. The technology may help to improve efficiency through e-filing system, also online hearing, and the digital access to legal information. However, the technology should remain a tool supporting justice, not a substitute for judicial wisdom and ethical responsibility. I forgot the fourth challenge. The fourth challenge that I focus is the growing number of the cross-border legal issue in Asia. Also, we have facing like cybercrime, money laundering, digital fraud, and the transnational dispute that move across jurisdiction. This problem requires strong regional dialogue and judicial cooperation. This is all my briefly. Thank you.
Thank you very much. And now I would like to invite Police Colonel Dr. Siriphon for your valuable insight.
I need some slide. As Professor Prasit said, we are subject something likeของพี่ไปไหน
Dr. Siriphon slide, sorry.
As Dr. Prasit said that the judge have to protect the rule of law, the justice and also the human right. When we said about the independence of the court in Thailand, I think since we have the court in a modern state from King Rama V, we reform at least 2 or 3 times for the court of justice. And still right now we have other court that have many problems in our the legal legitimacy and also the rule of law context. Let's wait for the slide. But as I said, that we have many problems in other court, and also we set up the new organization we call the independent agency or independent authority under the constitution. Some independent agency is very independent from any examination and also independent from the people. This is what we said about the separation of power. We have the executive power, we have the judicial power, we also have legislative. In Thailand, we have many other kind of special executive power that very important from the people. Who moved my? Sorry. What is the problem for my?
Not this one. Dr. Siriphon. So maybe while we're fixing the issues, we can switch to...
Not this one. This one.
This one, okay.
Okay, this is what Dr. Prasit already said, that about the security of the court to guarantee the independence, like the secretary of tenure, they have to be appointed and they have to leave until they get a retirement without any interference from the executive and also the court inside itself. And the second one will be financial security, the transparency of appointment procedure. That means how to get more promotion. In Thailand right now, have no special condition to get 2 or 3 level of the salary increasing. That everyone, if they have the good performance, they will get a promotion in the same level. So that is so good, and mean that no interference from the commander. If they perform well, they get a promotion by the law currently, and then we get the protection from the external pressure. That means in Thailand, the court have independence to make a decision by the court itself. But in reality, maybe it's not. We have in some case like human rights, free speech, or about some special case that about politics. That maybe the case, the court, the judge, independent judge itself cannot make a decision by themselves. Maybe they have some internal insight that interfere. Some case will be have to return the commander and then make a decision by the other. That is the reality. But when the law said about the impartiality or independent, the law is so good. It looks so good. This is what we already talked about that. But the main problem in Thailand that I think the court have very severe problem in situation, in special situation. In general, the court perform very well in general case, like the criminal law by itself. The court of justice perform very well. But when they are subject to the special case like particular politics case, free speech case, or majesty law case, that's it. very strange from what we already try to get the idea of the court independent. That is what we try to study, and also we try to change, to reform, but it's very difficult, and we don't know why the court that cannot perform well in some special case like that. Right now we have special court like the Constitution Court, and in Thailand, if you go to the public opinion to find the public opinion, no one trusts the court, some court, and that's a very big problem where we don't trust the special court.
About 1 minute left.
Okay, and then this is information that I try to give for you. Right now, only the Court of Justice, we have the number of the court, and we have the senior who already retry from the system, but they still work and get very high salary. And some court, they haven't worked anything, they just get a salary. That is a big problem. This is a salary they get that is very high. And then now, what I said, it is far from the people, because right now, the committee to administrate the court, there are no person who representative from the general person anymore. This is what I say. Independent from whom? Independent from what? From the people, right? Independent from the people, general. Independent from the examination from the public, or independent from whatever. And the court, the main problem with the court, they don't care about ICBPR, the International Convention of Political and Civil Rights, and they don't care about the constitution provision in some situation, because they extend their power to make a decision without the basis from the constitution provision itself in some situation. So what I said is independent from what? And when they get a disciplinary action, we don't know anything. We just know the report to the public that this judge has been make a resign from the disciplinary action, but we don't know anything about that. We don't know the fact, what happened to those judges anymore.
Yes.
Okay.
Yeah. Thank you very much.
Okay, you can get my slide too.
Like there is a lot of details actually in this session. So if anyone in this room would like more details regarding each specific discussion from each panelist, we can ask them directly after the sessions, or ask to send the PowerPoint slide, right? So as we have been discussing a lot in the main team here, that we need to have judicial accountability and judicial independence or autonomy. I would like to ask, in the big picture, in comparative manner between common law system and the civil law system, of how you balance, between the accountability and judicial autonomy. Are there differences between these two systems, or are they have the same principle? So may I start with Mr. Mohamad Izhar?
Unfortunately, I'm the only one here from common law, so I have to answer that question.
You are lucky.
Okay, all right. No problem. Thank you for that question. So I wouldn't be able to give my views from civil law, but I think what I mentioned to you earlier is that we had a reform in terms of legislation in 2009, which actually codified judicial appointments through the setting up of a commission. I think that was a good step in the positive direction, because it's a step to trying to make the process more independent and also transparent. I believe it was largely mirrored from the UK legislation. But having said that, I think going back to the themes of today, and I thank Professor for being very candid in highlighting a lot of the issues with the judiciary. I mean, I think that's quite common across most jurisdictions. I mean, we won't say it out loud, but those are things that actually happen on the ground. I think the legislation, I think two key themes. Number one is to introduce the merit-based system, right? So it's actually mentioned in the law itself. What are the qualitative requirements? I mean, I don't believe qualitative in itself is sufficient, because at the end of the day, it's up to the decision maker to determine what those qualities are and whether the individual has that particular quality. So it does give some guidance, but obviously it's not exhaustive. But again, it has come a long way. And I think the second one is trying to remove the decision from a sole individual, right? So instead of one person essentially approving the appointment, and then it goes to a commission that is appointed democratically, and also vetted the particular candidate, and then it has a process to it, as opposed to being I guess not transparent in that sense. So those are good reforms. Obviously there are some deficiencies with that model, but at least having that merit-based system hard-coded in law or legislation is a positive step for us. Thank you.
Okay, so in the common law system, the law itself created by the decision making also as a precedent also, right? So it's essential that you also governed by the court itself.
Correct. So the law sets it out, and then the court will interpret.
Yeah, so this is like kind of different from the civil law system that we have separate legislative system. So may I now ask Dr. Siriphon of the balancing of the institutional accountability with judicial autonomy in your perspective in terms of civil law system, how can we balance them?
I think when we talk about the balance of independent and also the public interest, we found that in our country, like civil law country, that we cannot criticize the court's judgment directly. We have to assert that we, under the academia idea, we think this what with the respect of the court decision. So we cannot criticize directly. We cannot blame. We cannot whatever that we think that impolite one. But what I say that we try to make the transparency of the court, that we have to revoke the contempt of the court provision, that make the court become more challenged, to make more the court more transparency, and then prepare to be criticized by the public interest and public people. And also, I think the disciplinary action must be reveal the detail what happened to the court when the judge had been discharged from the court. In some disciplinary action, we don't know about anything at all. What happened to the court? That this is not it's not good for the public interest, because most financial that we invest in the court to let them protect the civil justice and also the human right. So what I try to say that in case of we need to more transparency of the court. The first one, we have to revoke the accusation of the court contempt, and the second one, we have to reveal more information, and the third one, that we should have more people to get involved in the administrative of court. Right now is far from that situation. So and okay, maybe that's all.
Okay, thank you very much. So you think that the court needs more transparency, right? And involve more people that they allow to criticize the judicial system. So in other side of the things, that people criticize a lot from the court too. I agree though that we need to be able to more criticize and transparency in terms of the court system. But what if, the digital judge, like, people criticizing, scrutinizing from the media or political people, as you mentioned in your remarks, how in today's governance landscape should the court respond to the increasingly scrutiny from the media, civil society, and digital platform? May I ask Professor Prasit?
Don't forget that some media has a lot of powerful in terms of interference to give some favor verdict for politician, for the leader who is behind this curtain. Some politician doesn't use any kind of direct connection with the judge or judges. They use the media, and they can build up the sentiment of the people in the public in order to keep that trend of decision. So we all know that sometimes recruitment of the senior in the parliament, sometimes the media make a lot of influence, and that's why the result of the election, sometimes the people are so sad with the result of the election. That is the way that we call dirty politics, and how the judge, especially constitutional court, the judge in the constitutional court can play the role as a guardian of the rule of law. If the judges in the constitutional court play the role as the slave of the politician, that nation will be sank down immediately and go back to the corruption state. As you may know, the CPI index, Corruption Performance Index, in this year, some country has already sank down and go deep down at the same level of some least developed country. I don't want to mention the name of that country. Why? Because justice is not guarantee the freedom of people anymore, due to the judge sold the spirit of justice and play the role as a slave of the politician. And that's why I think that judicial independence is not enough. We need to have judicial reform as well. At this moment, I think that time may be constrained. I cannot talk about the judicial reform in detail. Thank you.
Yeah. So from your perspective, that the judge need to strictly not to be a slave or sell their souls to the media. Yeah. So regarding the media, may I briefly ask Dr. Pratamaporn about the public communication strategy from the court themselves as outreach initiative? How can the court improve such outreach initiative for the better understanding and trust in the judicial process?
So the public trust in the judicial depends not only on correct legal decision, but also on whether people understand how the judicial process works. Court should communicate more clearly and transparently through public legal education. Maybe we give the education, or we promote on the TV like a little bit short advertising, but like because many people cannot understand the process of nowadays judge. So if we introduce or improve more understanding for people, maybe it's better, and they're gonna make people understand and trust all the process for they can rely on the judgment process.
Okay.
Yes, thank you.
Thank you very much. It seems like we still have more time. How many minutes? 15 minutes. Okay. You want to present it to the... Yes, it's okay. Yeah. You need the slides? Okay. Is it possible to use the slide, or is a mechanical problem still? Maybe.
Not this one.
But it has to be brief, though.
So that is not my slide. Judicial interpretation. Yes, okay. Go back. Please go to the page of judicial reform. Yes, sir.
He needs to press in the.
Here, I would like to show you that according to my opinion, we need to have a good judge, and then that's why I would like to talk to you about the judicial reform. First of all, to be a good judge must have a good knowledge in law, not good knowledge in other fields which are not law. Sometimes we recruit judges from the economists, politics people, political people, famous people from the media to be judged in a constitutional court. That is sometimes make a lot of problem, because when the judge have not enough knowledge, they can make a ruling as a prejudice ruling. And sometimes that ruling become a bad standard, and the lower court need to follow that standard. Imagine how the justice of that nation can be maintained. So that's why education of the judge need to be reformed. According to my opinion, magistrate school and training program for the judges need to be organized by all countries around the world, not in Asia, around the world. So all judges need to have solid knowledge of law and legal practice. To become a judge, the candidate must earn at least a bachelor degree of law and can pass the bar exam and gain significant legal experience, 5 years or more as an attorney. Without practice, you just pass the exam of recruitment and you become a judge at the age of very young age. How can you imagine that the judge which have any experience before can understand the problem of the family law, can understand the problem of the woman, especially equality of gender? That is a big problem. Sometimes young judges need to, according to my opinion, I think that young judges need to have a solid training. And that's why we need to have a mature judge. The judge must be mature, not to be not to be a new driver of the justice. look like you are a new driver of the car. You may make a lot of accident, right? As a judge, it may be okay. Not only that, integrity reform. All judges must be honest, ethical, and having strong moral principle, regardless of anybody who will criticize them. And judge must not involve in any kind of corruption. So judge must come to the court with clean hand. Not only the party in the case must come to the court with clean hand, judges also, and it is a must as a role, imminent role of the judge, important role of the judge. Finally, judiciary system must be strengthening by and must be cooperated by all partisan in all society around the world. In order to have a strong, independent of judges, in order to have a fair judgment, in order to have a good law and good justice. So law is just not a norm which has a legal binding force. Law must have justice as well. So judge can play this role and can render justice to all people. Especially judge can be a guardian of the justice, according to my opinion. Thank you.
Thank you very much, Professor Prasit. And I think we come to the conclusion now because the time is up. Actually, I really want to ask briefly, like, in one sentence. I just want you to leave the message that you think is the most essential to the audience regarding this topic.
Okay, mine's very simple. I said it in my opening slides. It's not a issue or problem in isolation, right? You can undertake reforms in the judiciary, but it's part of a bigger problem because if you look at the whole ecosystem or value chain, it's all related. So it's related to the executive, it's related to the legislative. So you can, I think the key question you're going to ask me also I know is what do I think would be the key reform for judiciary, and I think that is obviously judicial independence. That was also said by, I think in the opening remarks, it must actually be done. So there's actually need to have political will to do it. It can't just be seen to be done, but needs to actually be implemented. So at the end of the day, whether that person still has discretion or autonomy in the law, on the act, it says something, but in practice, something else happens, right? So that's quite unfortunate, but that's one. But in order to address, rectify the whole problem, we need to see it from the whole ecosystem, from the legislative and also the executive side.
Thank you very much. Actually, I would like to ask more from the civil law perspective from one of you, but the time is pressing. I have been stared at. So now we have to really conclude. Okay, 30 seconds.
No problem. I said that in Thailand the judicial is so good in general case, but we need to rethinking about in some politics case, in some free speech case, in some ICPPR that get involved, and also some court might be instantly reform because as Professor Prasit said about the Constitution Court, we look into the public trust maybe 0 or not more than 1 from 10. Okay. Also about the court itself, I think the judge must be proud to be the judge, and then make the justice become true. Not only the justice in the books, but it must be true in real life. And then I think that when we talk about the justice in Thailand, I think most of them are so good, but in some special one, that must be reformed. Okay. Thank you very much.
Must be good at heart and soul as a judge. So thank you very much, all the panelists today. And now I must hand over the panels to Mr. Thanuwat so we can have the appreciation sections. Thank you very much.
Thank you very much for Ms. Lily and the panelists, all the panelists on the stage. That would be very, very fruitful discussions here today. Right now, I would like to invite Dato Sri Dr. Mohamad Izham Sairi, Honorary Advisor of ISI, International Strategy Institute, to provide the token of ceremony of appreciations to the panelists and our moderator. Please give a round of applause. So before going down, could you please? Okay, for the last photo, please make the group photo together for the panelists and please wait a bit time. One more photo, please.